Good morning. Welcome. My name is Ty Crawford. I'll be your moderator for today's event, and we are excited to get into the music business conversation this morning. The music business conversation is powered by the Music Tech Conference, which is a unique platform to discuss digital transformation and business opportunities in the music industry with artists, musicians, composers, promoters, academia, government, and experts in technology and digital platforms, finance, lawyers, and experts in intellectual property, copyright, patent, and so much more. So the idea today is to discuss the music industry's transformation through information technology and the opportunities digital technology offers to impact lives. Our goal here is to empower, engage the emerging generation of artists and musicians to leverage technology to thrive in business and life. The business conversation is powered by the Music Tech Conference. This year's Tech Conference is June 11th through 12th, at the James L. Knight Center in Miami, Florida. If you haven't gotten your tickets already, please don't wait. Get your tickets now. This conference won't be ordinary. It will be extraordinary, and you don't want to miss it. We only have 2 hours today, so I'm going to get straight into our speakers. We've got two wonderful speakers for you today. We've got Rebecca Baylor. She is an award-winning entertainment, business, and trademark attorney and is the visionary behind RPB Law, PLLC. Prior to launching her own firm, Rebecca worked at Sony Music Entertainment, Hot 97 radio station, Viacom CBS, Ackerman, and most recently, Amazon Music, where she negotiated one of the largest label deals valued at $1.2 billion. So she knows her stuff, guys. In addition to Rebecca, we've got Alexander Leveco. He is a New York licensed attorney at the IP and entertainment law firm Chase Lawyers in Miami. He has years of international experience in intellectual property, entertainment, licensing, and internet law, and has advised major brands, including Vimpelcom and Masha and the Bear. So welcome to you both. I am not going to take too much of your time. I want to get straight into this conversation today. We've only got 2 hours. And we're going to get straight into Business 101, right? So, Rebecca, kick us off.
Awesome. Thank you. Thank you so much. Thank you to the Music Tech Conference. Happy Intellectual Property Day, everybody. That's exciting. A good way to spend it. Learning about IP. Alex and I are going to give you all the goods between copyrights, trademarks, Music Business 101. My favorite part, how to monetize your IP. But before we get into those details, we're going to essentially just lay the foundation. So before you even get into your IP, we're going to give you an overview of who typically is on the artist team. I'm sure you guys have heard of the attorneys, V and Alex. I'm sure you guys have heard of a manager, and I'm sure you guys have heard of an agent. Oftentimes, these roles are confused with one another, but we're going to go through each one. So there's two types of managers. There is a personal manager, and then there's a business manager. For an artist, producer, whatever type of talent it may be, the personal manager is the individual that really runs the day-to-day for the artist. So they run they take care of all logistics, and they serve as a liaison between the artist and everybody else on the team. So for instance, say the artist has an appearance on Good Morning America. The personal manager is going to be the individual that's going to make sure that the publicist has that information and that information is being disseminated to the appropriate parties. The personal manager is going to make sure that your backup singers and your backup dancers are there, or makeup artists, stylists, whatever it may be, all the different moving pieces. The personal manager is putting that together and making sure that you are ready to perform, to appear, whatever it is that you have to do. They're the brains behind that. Now you have your business manager. The business manager takes care of most of the financial aspects of artist career. So they handle the budget. Sometimes they provide tax advice and just financial advice in general. They do something very important. They collect your royalties and manage all of your revenue. Super, super important. They make sure everybody on your team gets paid. They are there to protect and advise the artist from a financial and business perspective. So they're both of the managers play a very important role, but they both do very different things between the personal management and business management. Now, let's get into the role of an attorney. I may be biased, but I think they're one of the most important pieces to the puzzle. Attorneys typically, we review agreements, we negotiate those agreements, and at times we even draft those agreements. So depending what agreement it is whether we will review and negotiate or whether we'll draft those. So for instance, say an artist, you want to clear your music. Your attorney will be negotiating that agreement to make sure that any producer or anybody that is a songwriter that's featured on your song, that music is clear so that you could appropriately use it, have rights to use it, and ensure that you're not infringing on anyone's IP. My colleague Alex will go into that a little bit more later on today. The attorney also handles disputes. So much as I'd like to think that, you know, it's a smooth sailing and there's no issues, that's not always the case. I don't know if you guys recently heard, there was a TikTok rapper who did not clear his music and he was ordered to pay around $800,000 to Sony for the infringement. So these are the type of things that could potentially happen if you don't clear your music. So that's super important. But then you also have the attorneys who negotiate like your live performance agreements. So say Coachella or Rolling Loud invites you to perform. You need to make sure that those contracts are negotiated in a way that it protects you and that it protects your intellectual property, it protects the content. For different types of talent, for instance, like comedians typically, they don't like their content getting out there, so they need to make sure that there's a provision in there that people collect your cell phones prior to the show. So there's a lot of different things that the lawyers do outside of just purely the IP, but they're really ensuring that you're fully protected. They're enforcing your IP as well. So any IP that you do have, they're making sure that there's no one infringing upon that IP and that you're able to utilize that and profit off of that exclusively. Finally, there's the agent. The agent is very important as well. They're the ones who go out and pitch you and get you gigs, whether it's a show, appearance, any type of bookings. They're securing endorsement deals for you. They're securing sponsorship deals for you. They are building relationships with different venues and promoters to make sure that you're remaining booked and just top of mind. They really help artists expand their audience, expand their reach, and make sure that you are constantly in front of an audience. They're helping you secure merchandise deals. There's all different types of deals, makeup, perfume, all the things. They are the ones who are leading the front on that. Now, these roles all work interchangeably, right? So between the business manager, the personal manager, the agent, and the attorney, they're all working together, and sometimes they overlap. Sometimes the manager is aware of an opportunity and they're able to pass it along to you. Their primary focus is to manage what's at the table, but there could be some overlap. Sometimes attorneys have connections and they're able to make an introduction. But again, each of those primary roles have their functions, but they all work together to create the artist team. So that's the background on the music side of the business. Alex, did I forget anything?
I don't know, like we want to talk about how usually with the artists, it's usually one person who is their boy from back when, who's doing all those 4 jobs. And then at a certain point, they realize like, oh, we're making $600,000 a year. We should get somebody whose job to actually do those things. Yeah, I see those examples pretty often. It's something where I think the roles themselves don't necessarily have to be set in stone, right? As Rebecca mentioned, that they may deviate from one another. There will be overlaps. Now the question is, does the artist know what roles need to be fulfilled generally, right? Oh, I need somebody to handle my sponsorships, to handle my social media, to handle my bookings, to handle my licensing deals, to handle my placements. As long as you know the to-dos, so to say, it doesn't matter whether one person does them or 3 people do them. It's just a question of how effective are they at getting the job done, and other 10 things that need to be done are getting done. And this is one of the things where having an experienced manager, attorney, agent will allow you to have a knowledge, a little bit more education in regards to what is that full scope of things that I need to be doing in order to be advancing my career. Because I think one of the main issues that musicians have at the start is that miseducation or lack of information, right? Because it needs to be, it's hidden in the books somewhere in the dark shelves of a, music business 101, by Passman or something like that. It's one of those things where you need to get that exactly. Here we go. But
this is the book I'm talking about, guys.
Yes. You need to either go to 15 different seminars on how to and this is one of those seminars on how to make sure that you know your music business and you know when to ask those questions from your team. But it is very important to have that team, at least be cognizant of the fact that you might need it down the road as your career progresses, because you can't be doing everything by yourself. You can to a certain extent, and I've seen success stories, and I have independent artists that have made 7-digit yearly careers based on recording in the bathroom, right, or in their in their respective bedroom. I have seen that, but then it's you can't follow an exception to the rule when the rule generally is you need assistance, you need support, you need foundation, and you need to have proper structures in place to advance anywhere. So I'd say that'd be my kind of feedback on the topic there.
Yeah, no, I totally agree with you. I definitely see oftentimes your best friend, or again, it's okay for that to happen in the beginning, but there definitely comes to a point in your career when you do need to recognize that you should have experienced professionals in those roles so that you're not signing away the rights to who knows what. But yeah, no, that definitely is very important. That segues us into the next really important thing. I like to say there are some must-haves and there are some, it would be nice to have that. These are one of those must-haves. Before you start doing business in the entertainment industry, it's super important that you establish a business entity that will be the entity that enters into all the agreements that you, all your contracts essentially. So I'm sure we've all heard of, like, let's say a particular type of business entity is an LLC, for instance. An LLC stands for limited liability company. And what that does, it literally limits your liability. It serves as a divider between your personal assets and your business assets. Typically, it's referred to as a loan out company. Sometimes it's referred to as a furnishing company, but it's the company that you're providing your services through so that you as an individual in your individual capacity are not entering into these agreements. This is really important for a few reasons. Say I'm an artist, I decide to release music and I didn't clear my music, and now I'm getting hit with a cease and desist letter, and I learn that I'm infringing on someone else's IP. The only assets that are on the line for that particular lawsuit are the assets that are within the business. Now, say you entered into an agreement in your individual capacity, all your personal assets then are on the line as well and are at risk. So super important to separate the two. I like to tell folks about a quote from Jay-Z's song. Or no, I think it's Kanye West's song, where he says, "I'm not a businessman, I'm a businessman." And you have to think of yourself in that same way. You are the business. Yes, you could be a businessman, but ultimately you are the business, and you have to operate as a business. You have to move as a business. Separating your personal assets from your business assets also just allows for just cleaner books, right? We don't want to confuse the two. Fancy language is called piercing the corporate veil, where it essentially, if you mix the two too much, the courts might look at it as one and the same. And we definitely don't want to do that. We definitely want to make sure that you're getting the benefit of all your business transactions. You're getting to do your tax planning appropriately. That gets into the nitty gritty, but ultimately remember that when you are doing business as a business, you want to enter into all your contracts as an entity. And that's, again, this is a must have. And it's for every line of business that you have as well. So say you're an artist, but that you also, you're an actor as well. You should have a furnishing company for all your acting work. You want to keep it clean and divide all your companies into separate different entities so that those assets remaining with that particular type of talent that you have for that regard are only within that one entity. Anything I forgot?
Yeah, I would say I would also add to that generally, the separation of assets, right? I kind of like to follow the people and the money, so to say. If you have separate distinctive businesses that have different revenue sources or different type of folk that you are negotiating and contracting with, right? You have one vehicle that is B2B, you're providing services on private events to, you are performing. Then you have another one that is, you selling merchandise to your fan base. And then you have a third one where you executing sponsorship deals. It's regardless of what business you're in, entertainment business is, in no way, shape, or form different. You want to make sure that you create that separation, just to avoid commingling, avoid having, that liability, that corporate veil pierced, and also just making sure that you protect yourself and kind of structure your financial assets intelligently, which is very helpful, to do it at the forefront of things, right? It's always easier to do things properly first time than to have fix them down the road, it's going to be more expensive for you. It's going to be more arduous for you, and you're going to just waste a lot of people's time, including your own, if you just kind of have things fall by the wayside and then expect things to resolve without you having to, kind of put those structures together. This is unfortunately, a scenario that, we have to deal with pretty often as attorneys, as people coming to us after something have gone awry, as opposed to, at the beginning where, oh yeah, we could have set up an LLC for you and set up an independent record label for you to sign yourself, or, have it be a loan out situation, whatever the agreements between yourself and that company is. But it kind of puts that responsibility onto the LLC and allows you as an individual to kind of stay back behind that protective corporate veil. Yeah, I would generally say just, make sure that you are treating your business as a business from the get-go, regardless of whether it's making business like money or not, right? And it doesn't necessarily, kind of to shed a little light on the expenses involved, right? Or I can, confirm it, from your experience, but registering an LLC is not necessarily even something that you do need an attorney for. In my experience, you can just go to a registered agent website. You can go directly to the State Secretary of State website. Every one of those has a certain breakdown of how to do it. It wouldn't take you more than 25-30 minutes. There is obviously some additional level of consideration that needs to be taken into account if you have multiple members in your LLC. If you want to have your business partner or your agent be, fortunate because they're your boys, whatever the case, maybe that's usually the independent kind of scenario where you set up a company and then you are running your label together. And obviously, the more people or money sources you involve into a particular business equation, the more you're going to have regulation there. Oh, we have not one member of the LLC, we have two, we have three. Okay, we need an operating agreement. Oh, we have, a certain partnership or collaboration scenario or licensing scenario. Okay, we need to make sure that we have documents in place for that. But generally speaking, setting up an LLC for yourself, getting yourself an EIN number, the tax number that's needed to open your bank account, and then opening the bank account, all of those things that I, usually, I offer the help to the client, but I also outline the fact that they can do it by themselves. And this is not necessarily something that will take you, into the red in your bank account to pay lawyers to do that service. So just make sure you do it in advance so you're protected. So then you don't have to overpay for fixing issues that could have been prevented. So.
Totally agree. And that was a really good point on the EIN. The EIN is like your social security number for your business. It stands for Employer Identification Number. Super easy to get it. IRS.gov. You'll get it instantly, literally within minutes. And that's what you need to open a bank account. So when you get paid, make sure your business bank account's getting paid and not your personal account. Just taking things from a very organized, like just being super organized from the beginning is going to save you a lot of headache on the back end. Ty, did you say something? Were you saying something?
Yeah, I just wanted to ask a question. All of these fundamental pieces that you guys have talked about, the personal manager, business manager, the attorney, the agent, and the LLC. I don't want to answer this, but it sounds like LLC should come first. What would you say to a new artist that's kind of maybe with their boys, like you said right now, but is it LLC first? Is it agent, then LLC? How do you, what's the best way to step into this if you do have the opportunity to plan this out properly?
Yeah, I would say your LLC is one of the very first things that you do. Because that's whatever agreement that you enter into, you want to protect your personal assets. So my recommendation is the LLC, and that's honestly one of the simplest things that you can do to really just stay organized. Typically, an agent, attorney, personal manager, business manager, that doesn't come along until you're more established in your career. Or as Alex mentioned, it's one person kind of doing all of the things. But it's important to understand the business side of it, that, when you get to that level, that you do understand that these are all important pieces to the puzzle. So that's why we talk about it and give you that background. But I certainly think the LLC is one of the first things that you should do. Anything else, Alex?
Yeah, I would say so, definitely, because A, there's the upfront expenses, minimal. It's $200 to the government, and you got your LLC, and then you have to renew it every year for another, $100 or whatnot, depending on the state where you do it. Getting an IN is obviously free. Just do an online application, 5 minutes with the IRS, and then you take your IN and the corporate formation docs, and you go to the bank to open the bank account, and now you're connected to all the different, collecting companies, your DistroKits, your TuneCores, etc. And that's,
Yeah.
how you kind of establish that, sources of money to the LLC connection. I would say everything else, right? The truth be told, so the manager, the agent, the manager probably is going to be involved in your career from the beginning, most likely, like the earliest out of those, three individuals: manager, agent, and lawyer. Just because most likely you're going to just need some assistance at the beginning to get your career going, to make sure that you have somebody negotiating conversations when you get when you start getting picked up for tours, or performances, or you get collabs put in front of you. So the moment that happens, you're probably going to need to have some original assistant. The agent, as Rebecca rightfully mentioned, is probably going to be somebody that an artist would come to at a later date, when there is an existent level of kind of hype behind the artist and the following. And that will just allow the agent to be a little bit more effective, as opposed to if the artist is an unknown commodity. In that the agent is going to be able to actually place you in things, right, and actually provide you with those opportunities. But that's, once again, is at a certain stage when you've achieved some of those milestones originally. Lawyers, I would say so that you probably need a lawyer at the beginning, right? But for the most artists, how it happens is that once you kind of hit those original milestones of, let's say, you're making $4,000 or $5,000 a month from your music, right? You have started picking up, type of thing. This is most of the time when people start going to lawyers, or even much later, just because of, you usually don't start getting opportunities unless you are making $50,000, $100,000 annually from your music. You don't start getting those negotiation opportunities put in front of you. Distributors are not reaching out to you until then. So record labels are not reaching out to you until then. And until that happens, until you are already a commodity to a certain extent as a result of your own promotional efforts, which I think is a little bit reversed in that before, labels used to come to you to market you, and now they come to you after you've marketed yourself. But it is a little bit of a reality of the game, where you can see everybody's numbers at the sheet of paper, by clicking a couple buttons. So that has led to the fact that artists, when they get to a certain stage, it usually starts happening around the same time. And around the same time, you start getting opportunities for agents reaching out to you with placements, and labels reaching out to you with, distro deals and licensing deal opportunities. And that's going to be the place when you're going to need your lawyer to assist you with all of that. So it's just a question of, how did your manager do your job? How well did they do their job to get you to this point? I would say something like that.
One thing I want to add to that is keyword on your lawyer. Sometimes when an artist is getting signed to a label or anything else, they think that the lawyer on the label is, and obviously the lawyer shouldn't represent that they represent you, but they're not your lawyer. Their lawyer is, for the label's lawyer is the label's lawyer. Your lawyer is your lawyer. Same deal with agents. Sometimes, artists will have the attorneys at the agency negotiate their agreement. Sometimes they have their own attorneys represent them. But keep in mind that an attorney has a fiduciary duty to whoever it's representing. So, do your due diligence, and keep in mind that whoever you hire is going to have your best interest. Whoever anybody else hires is going to have their best interest. So I don't want you to get caught in that trap where, like, oh, a lawyer looked over this, and you sign it and you're not really quite sure what you're signing. Especially now, ownership is really important, and you want to be able to control your assets as much as you can, depending on how much leverage you have. But yes, getting your own lawyer is important and key.
Yeah, one other thing is, make sure, like, lawyers are not all the same. Like, if somebody put a personal injury case in front of me, I wouldn't know what to do with it, because I've never done it. So it's the same thing regarding entertainment. If you want to hire somebody to assist you with your specific distribution, record label management, live performance contract, get somebody who's doing that on a daily basis, who is sick of those contracts at this time, as opposed to somebody who is so excited that they want to get out of the rut of the real estate transactions, and now they want to get into the entertainment world. that's one of the issues that we have to fix for clients from time to time, is that, oh, I've had this attorney, review this contract or prepare this contract. They're not really an entertainment attorney, but they've had a couple of entertainment cases before, so they're going to be able to help me out here. Well, most of the instances, no, because obviously the more experience you have in something, the better you're going to be at it. So make sure that you are as niche about the selection of your attorneys as you are about, anything else where you're looking for professional assistance, because all lawyers don't equal the same in that sense, and everybody has their specific, set of expertise.
Totally agreed. Totally agreed. Yeah. It's like you wouldn't go to an eye doctor if you had a skin issue. Go to the dermatologist. Same thing with lawyers. We all specialize in different areas. So you want to make sure that you do your due diligence and that you're hiring the right person for, whatever the transaction is that you're entering into.
Mm-hmm.
All right.
Rightfully so. Do we want to move on? We'll talk a little bit about music copyrights and how we look at the two different sides of the equation there.
Yes, so we laid a good foundation. Let's get into copyrights and royalties.
Mm-hmm. Well, so when we talk about music and copyrights, I think music is, it's not necessarily, the most complex industry, but it does have so much, this niche terminology, and it has those different specific rules that have come onto the existence just due to how the industry developed itself over the past 100 years, right? We have terminology like mechanical royalties, because before it used to be a mechanical roll that, determined how many, copies you can make. There's still certain clauses and agreements that just don't make sense anymore about, like, oh, the broken CDs or whatnot, when nobody has printed a CD in 15 years. Now, this is kind of one of the things that I think every musician who is starting their career should definitely have an understanding of. And this is the two types of music copyright. So as we know, copyrights protect creative output that is fixed in a tangible medium of expression. What it means is, if you put something in a microphone on an MP3, if you put something on a piece of paper where you draw it, if you put something on a canvas when you create a painting for somebody else to perceive, meaning it's not just in your head, it's not just a conceptual idea, it's actually something that's received an expression in the world for other people to enjoy, then that is usually protectable by copyright, provided that it is original. Now, in the context of music, we have a music composition, which is usually considered to be the underlying melody and lyrics of the song. And then we have the sound recording, which is the final version of the song that gets fixed in that MP3 format that is recorded on your studio, right? So depending on that kind of knowledge and separation between the two, oftentimes dictates how successful musicians are, first and foremost, when they're negotiating their original collaboration agreements. Obviously, when you're first starting out, you're going to be working with a lot of different people. You're going to be working with some people where you're kind of on equal footing and you're just collaborating for the sake of collaborating. Then you're also going to have instances where you're going to somebody for a certain level of clout and they're following. You want to work with this producer because they've worked with Kendrick before, and you want to make sure that this particular sound engineer does this hook for you because you want to get this specific sound that they have provided to some of their previous clientele. So whenever you are in those conversations, having the knowledge between, okay, this is music composition and this is the sound recording, allows you to understand a little bit better what kind of percentages should everybody get depending on their level of participation. And this is where, if you don't do that kind of preliminary assessment, like, oh, I have 3 people where I'm working with on this song. This guy's helping me write the actual melody and help me write the actual lyrics in the song. And we are both splitting, the different verses that we're doing. Okay, we're going to be joining in the composition, but for the sound recording, we also have the sound engineer who's going to be adding to the equation. And this is where we kind of have to determine, is he going to be an equal participant with the 2 of us? So it's going to be 3 people sharing in the sound recording and 2 people sharing in the composition, or do we want to do work for hire, where we hire the sound engineer, pay him money, and have a written agreement signed that makes everything that they create our property, so they're excluded from the ownership, but they get the upfront fee, or do we license the work from them? So there's a couple of different ways how you can go about structuring your ownership of the song, but the only way to properly do it is to do it in advance, kind of thinking through it, because oftentimes what happens is you go into the booth, right? And that's where my rule is usually all the papers need to be signed in the booth. That's how I usually like to approach it. That's my perfect world scenario. Do it at the beginning as opposed to then having to chase people afterwards, because you have 10 unreleased songs that you've recorded and you're running every after songwriter trying to get their songwriter split agreement executed so you can share the compositions. Now you are running after every mixing engineer and sound engineer and producer for this co-ownership of the sound recording, and you're trying to put together work for hire agreements, which is not necessarily something that will prevent you from advancing in your career often, but it might slow it down, right? And it might, as Rebecca pointed out, sometimes lead to litigation in some instances when you haven't cleared works properly. But yeah, we'll talk a little bit more about the negotiation when we get to it. Rebecca, you want to say something?
Yeah, something I might add that actually happened to one of my clients is I like to tell people only have who you need in the studio to be there. Because say you have a random friend that's in the studio supporting you, all good. Here's where the issue is. This one friend contributed maybe 3 or 4 words to a song, and now they want the rights to that song. And sometimes, folks can't really remember who contributed what, who said what, who did what. So I like that you keep it clean. Whoever needs to be there should be there for a purpose, especially if you think that there may be some issues trying to finalize who did what, who owns what. And then also, you don't, like Alex mentioned, you want to get this stuff taken care of on the front end. Worst thing that's going to happen is, say you release a song and now this song has, picked up a lot of popularity, and now you're trying to negotiate. I promise to you that negotiation is going to be a lot harder if that song blows up than it would have been if you would have done this from the beginning. So again, it's the same theme that we're kind of going with. Be proactive, do things right from the beginning so that you're not trying to clean up a mess, chasing after people on the back end, especially if you need to release music and you don't have those rights yet. It's a risk. You're taking a risk by releasing without really clearing.
Yeah, it's interesting how the industry works, right? And there's obviously the legal right way to do things, and then there's how things are done, right? Because oftentimes we are in negotiation, and we represent an artist. We have executed a record label deal with them, right, or a distribution deal. That's for the most part what everybody's executing these days, thankfully. We executed a distro deal, but now we are realizing that there's 6 producers on this album that haven't been cleared, and that where the licenses have been obtained through BeatStars that need to be significantly changed and things of that nature. And then the labels just rely on representations and warranties. So, and then it's kind of like, oh, if anything happens, we're just going to pass it down to the next guy, double it and pass it down to the next guy, whatever that TikTok trend is. But yeah, thinking of that kind of song composition and work composition at the beginning, and being cognizant of, okay, this is my composition, this is going to affect, my revenue streams associated with the radio and plays and the mechanical royalties, the public performance royalties. And then we are looking at the sound recording, and this is a significant portion of, if I'm a performer, that's going to be the majority of the income. That's the money that you get collected from distro kits and TuneCords and CD Babies, or that your label collects on your behalf, as well as sound exchange income and some licensing income as well. But it's depending on what your role is, you're going to have different reliance level on those 2 different sources of revenues. Like songwriters whose function is not to perform per se, but to create great songs for existing artists who are already doing great. They're going to be collecting their lion's share from the compositions on the publishing side. And then if you are one of those performers, or if you're a producer, right, who's contributing to tracks and creating beats and taking points off of the sound recording, then the sound recording is going to be more important for you. But you need to have that knowledge, including the beginning portion of, oh, this is how copyright works, right? And what Rebecca mentioned regarding chasing people down and negotiating at the kind of back end, the problem is that Copyright Act considers everybody who contributed to the work an equal contributor, right? So if there's no agreement delineating, oh yeah, you own 50% and the other 3 guys that contributed, to some extent own a third of the other 50%, or however you want to split it, it's all going to be split 4 ways, right? And it's going to be 25% each. So usually the agreement is meant to, and depending on what position you're in, so to say, it's like in some instances you're working with somebody who's bigger and you see that they're not, very prone to put some paperwork in front of you. there is some value in the paperwork by getting those splits, enumerated, because you don't want to be chasing after anybody. But there is also a certain argument to be said that if the paperwork is not put in place, then you're getting a larger share, because that's what copyright would determine. So there's a lot of variability in what instances and what scenarios you're in. And this is kind of, where having that team next to you is helpful, just because, when I was coming out of law school, after having finished courses in entertainment law, this was not the scope of knowledge that I obtained. It happens. So as you, negotiate agreements, as you look at, 15 of those in the last month, and then you start realizing that it's not necessarily always the legality of the things. There's a lot of different practical, like, quirks and, nooks and crannies that you need to make sure that you refine in every single scenario to get kind of to the most optimal result. With that, I think, we can, chat a little bit about the royalties, right? The in regards to what it is that the artist needs to do once they've set up that loan out company, once they have that team onboarded, right? I think it's very important to make sure you know the third parties who are responsible for you getting paid, because in some instances we have artists coming to us and we perform an analysis, for them. It's like, oh, well, tell us a little bit more about some of your existing, monetization streams. And it could be different scenarios. Could be somebody coming looking for a distro deal, right? Somebody who already has something in place, and we need to analyze whether the advance offered is in line with what they're actually making. And this is when we kind of start going like, oh, are you registered with the PRO, the performance rights organization that collects funds from the terrestrial radio and the different, event venues and the different bars, restaurants, etc. Then you have mechanical licensing collective. Then you have some digital publishers, whether it be on the sound recording side with the Sound Exchange, or the publishing side with, for instance, Song Trust, who acts as a digital publisher in case you don't have one. And with every single one of those, it's very good to, and I think different resources provide kind of like detailed breakdown. I know MLC, the Mechanical Licensing Collective, has a very nice like breakdown and a very nice diagram on its website on where do different sources of revenues come from. But as an artist, you need to be responsible for knowing, where you get your money, just because, you need to be able to call people out on not delivering to you if that's the case. Oh, it's your business manager's job to go and register in all of those entities. You need to know what entities they need to register, or you're going to realize 3 years later that you just missed out on $500,000 that just wasn't collected, just because somebody didn't put your work into the specific registration system. And at that point, like, you can't really pass down that liability. That whole I'm not a businessman, I'm a businessman. You are at the beginning and end of your own success. It can't be a conversation about, well, somebody didn't do this for me. And so, well, yes, okay, but did you control them? Did you make sure that they did? Did you make sure that they didn't? So at that point, yeah, go for it.
No, I was going to say you're your biggest advocate, because you can have anybody on your team, but ultimately no one can advocate for yourself the way that you can. So yes, it's okay to put people in those positions, but you need to be educated enough to know what should be happening, what shouldn't be happening. And then obviously, you hired them for their counsel, which is fine, but you need to have that understanding, even at a basic level, at, where your revenue streams are coming from. That's a big deal. That's how you make your money. So if you don't even know the potential avenue to make money off of, then that proposes an issue.
So with that being said, can artists educate themselves to better understand their rights and entitlements?
A lot of resources, attending things like this. Alex mentioned a book earlier that I think is great. There's so many different editions of it. It's called All You Need to Know About the Music Business. It's by Donald Passon. This is how it looks. There's audio versions of it. There's the written text, gives you a good overview. There's other books I would recommend too, but not so much more for music, more so entertainment industry. I think one's called Hollywood Deal Making. But yeah, the more you, the World Wide Web is accessible to everybody. And there's no reason now that you don't have that basic understanding of what that's supposed to look like for you.
Yeah, I would also say there's one other good book that I've found for myself. I think it was written by an artist who actually started the blog. Ari Herstand, I think his name is. Ari Steak is the name of the blog, and I think How to Make It in the Music Business is the book. And it kind of does a lot of the yeah, I think it fills out some of the gaps with just standard legal music books that are very good at kind of breaking, those main concepts that we're talking about down. But when it comes to the nitty gritty of here are the 6 platforms at which it could be good for you to print your vinyls, right? And that this is the pricing, and this is how you go into the, weeds of saving money on your upfront expenses and printing merch cheaply and things like that. This is where I go to Ari's book usually, to get a little bit more practical knowledge. And this is also a very important element, I think, of any business in any like lawyer-client relationship. I think it's very narcissistic for attorneys to think that they know the business or better than the client does, and I think it shouldn't be like that. I think the client does have much more practical understanding of what their business is. It's like, oh, I'm doing very good on Facebook, and I have this community here, and then I have this tour thing, and I have this community thing, and I have this Discord thing happening. Whatever the case may be, your audience is better than your attorneys would. And kind of it depends on what business we're talking about. Unfortunately, in music, for whatever reason, just due to the creativity and the creative nature of things, I think there is a certain element of musicians just going, well, everybody's going to handle things for me. I'm just going to do music. And then, let's hope that the business work itself out. But that is just something that I advocate against very much so, is like, if you have had if you have taken the risk, right, so to say, to believe in yourself, to commit to your career, to treat it as a business, to invest into it, and hiring the majority of those roles, lawyers first and foremost, is going to require expenses from you, meaning that it is an investment into yourself, meaning that, well, now make sure to get the most out of that investment, and don't just leave the relationship with an attorney with some copyrights registered and some documents put together. Ask questions, get educated, figure out why exactly are those provisions needed in that contract. Oh, and what are some of the next steps? Because it just utilize the people around you as vessels with information and suck it dry. That's just my kind of general recommendation to anybody starting out in any industry. Be a sponge and make sure that you are responsible for your own success. So, and yes, YouTube and podcasts and 100,000 different, books online.
Yes, there's so many of those.
Yeah, let me send the chat the name of the book.
Names of the books, yeah.
Actually, I'm gonna throw a whole Amazon link into it. Just here I am facilitating sales, no referral codes whatsoever.
Thank you, Alex.
Yeah.
For sure. Ty, what else do we have on the agenda? Well, what do we want to move to next?
Let's get into copyrights and rights registration.
Also, the rights registration element, right? If we're talking about corporate, I think one of the most commonly had myth that some music clients come to us with is like, oh, can't I just send the CD in an envelope or to myself and obtain some protection as a result of that? Now the thing is that copyright generally vests in you as an author, as a co-owner, the moment you create something, right? So there is that, you have copyright in the work from the moment you create it. However, as of, I believe, what was it, 2020, the MMA Music Modernization Act, and a couple of court decisions, Supreme Court decisions, just requiring the copyright registration to be at the beginning of any litigation, be in the prerequisite to any litigation. You need to obtain a registration in your works, whether it be the music composition or the sound recording. If you have the same authorship composition, so you are the owner of both of them 100%, you can register them with the same application. But copyright registration provides you, and with any IP registration, provides you with some additional rights. It's the right to go to court. It's the right to have the presumption of your ownership, right? So it's the other party who has to, prove that they're not wrong, as opposed to you having to prove that you're right. And it's the ability to get some additional damages, get attorney fees, and get a little bit of better position in court when it comes to both the substantive part and kind of like the result part of it as well. Now, it also, in a practical level, significantly increases your chances of not having to go to court, because oftentimes how any infringement management process happens is somebody has a violation claim towards somebody else. They go to them and they assert that violation claim. And at that moment, either the party who have allegedly violated is going to say, well, go see me in court, or they're going to say, okay, I don't want to go. I think it's, a losing case. So let me try to settle this and get out of court. And this is, in my personal opinion, the best scenario in terms of if parties go to court. In the majority of instances, there's going to be everybody being unhappy because of the amount of time and money they spent on lawyers, because that's just what court cases usually lead to. It's in order for you to get a judgment, unless it's like a default judgment and nobody comes at the other end, you're probably going to need anywhere between $50,000 and $100,000 to get it across the finish line. If we are talking settlement discussions, that's a much more cost efficient way to resolve disputes, and that's what I kind of generally like to focus on in my demand letter scenarios. But if you don't have copyright registration, your arguments are just not going to hit as hard. Imagine you're coming to somebody and saying, well, you've used my song in your advertising and I need to get some compensation as a result of it. If you have the additional hammer of statutory damages and your ability to go to court, which the copyright registration allows you to have, and the statutory damages in that case being up to $150,000 per work in case of a willful infringement, those are some things that you can use while you are negotiating for a settlement, right? Or while you are trying to prevent them, have them take down the work, whatever is your preferred outcome. So there's a legal and a practical in it, and registering your copyrights allows you to achieve both, because if you don't do it, the moment you reach out to somebody claiming that they violated something, that's going to be the first inquiry back at you. Do you have the copyright? And if you don't, they don't really have to, address anything that you're kind of going to them with, because, well, go get a copyright and we'll see you in court is the most instances of response, especially when you talk with somebody major who has, $1,000 attorneys on retainer. They're just going to get passed down to those, and they're going to say, well, we'll see you in court. Like, we don't have time for this type of stuff. So if you want to obtain some leverage, get additional rights, get copyrights registered.
And the same goes for trademarks as well, for all different types of IP. Whenever you register your intellectual property, think of it as you going to court and just sliding over that piece of paper. It makes your argument so much stronger, and you save way more money than sitting there and now trying to prove that this is yours. Yes, you have the statutory rights, as Alex is saying, but there's nothing like having a registration in hand, where if someone is infringing, you can send that cease and desist letter, you can send that takedown, and you attach your registration, and it's like case closed. Most of the time, once people are seeing that, they're moving quickly. A client had someone send them a cease and desist letter, and the first thing I said is, where's the trademark registration? None was provided. So there's going to be a different response to those type of issues. And again, you don't want to end up in litigation. That's like not a fun place to be. Sometimes it's inevitable, but to the point where you could avoid it, do so. Invest the money in on the front end so that you're not sitting there spending all this money in court, fighting over something that, if you would have taken a proactive approach, you would have never found yourself in that position to begin with.
Yeah, you might be mad and angry now and they need to learn the lesson and all of that, but $60,000 later with no resolutions, and you are just in the process exchanging 600 pages of paperwork with the other side about everything and anything that happened with your business in the last 5 years, going to be a little bit less so inclined to continue with your, righteous, travel, so to say, right? Like, you just don't want to get into that process where you're like, oh, I need to sue them. It's like, you want to be financially driven in those conversations. What is the best, most optimal scenario for you? Probably get a little bit less, but right away without spending a lot. So.
No, absolutely. And like, nothing is a guarantee, right? You go, even when you're, it differs from copyrights and trademarks, but for instance, with trademarks, you don't necessarily have a guarantee that you'll get your application approved. But it's better to take that risk than taking the risk of going to court and not, spending all this money and then not having a guarantee that you're going to, win your case. So pick your poison, I'd like to say.
So while we're talking about spending, let's talk about collecting. We talked about the framework and the best way to start off. Let's talk about collecting royalties now. Where's the money?
Well, the money is, on those third-party sources, unfortunately. Well, it's an unfortunate and fortunate things. Like if you know the system, you can, collect your dues. If you don't, you're kind of left at your own devices. And I think this is the conversation that sometimes, pops up when we talk about new ways to earn. And this, one of the things, I've just had an ability to present an NFT NYC and another, Web3 conference. And a lot of people are talking about equal and fair distribution of royalties to musicians and how to use new technologies like Web3 and blockchain, and AI to achieve those, kind of new formats of collaboration between artists and their consumers, and to get them paid better. But the reality of things is that, the same as law does, the music industry is similarly very slow to move, right? It's very slow to change, and there surprisingly has been a couple of like recent changes in regards to providing some additional entities like the MLC to collect for royalties, as opposed to you having to run between your publisher and Harry Fox agency. But at the end of the day, there is still those 3, 4, or 5 major types of entities, and there's selection within the type. There's a selection of which one you're going to go to. But if everybody in the world who creates revenue for musicians, think of it as your Spotify's, your Apple's, your any formats of digital distribution of music that create those recurring revenues, which is the obviously the primary source of a lot of artists' revenues these days, if they're not prominent touring musicians. If that is the case, you need to go to the people who collect those funds from those entities, and that will be the PROs, your BMI, your ASCAPs, your CSACs in the US, and every separate jurisdiction, every separate country has its own PRO, and those are the ones who collect from radios and who collect from the venues and bars and restaurants. Then you have MLC, the one that collects mechanical royalties. Those are the ones when you do covers, right? When somebody uses Adele's melody to do a guitar solo on YouTube or whatnot. Usually, actually, they would need a synchronization license as well, but nobody gets those. They just get, mechanicals through Easy Song licensing. I want to also kind of mention the outside of the recurring revenue sources, which would be those PROs, MLCs, there would be Sound Exchange. It's an important one. You want to go there if your music is ever on Sirius XM or Pandora, any non-interactive streams. And then depending on, how, what is your statute as a composer, as a songwriter, you can also use the services of a digital publisher like Songtrust. But, I've had some negative experiences with those, but for some of my clients, they've been able to do their job extremely well. So it just depends on kind of like, where are you being listened to, who is listening to you, what jurisdictions do you need to have more emphasis on foreign markets, or do you need to be continuing to stay focused in the US one. But it is important to get a general knowledge of all of those entities and then register and perform those registrations with them. So in regards to every single one of the works that you release, to make sure it kind of needs to become a part of your checklist, right? It's like every musician has a checklist for what you need to release the music. Oh, cover art. Oh, upload to platforms, right? Oh, do this, make sure that all the documents obviously are executed, etc. And then one of those is going to be, well, uploaded to all of the relevant, collecting royalty organizations that will be the source of your revenues. So. Right. Hey, had any fun experiences with clients not having proper registration of the royalties, and you running around chasing those?
And it's not fun. It's not fun. And that's the reality of it. Majority of the time, those are not done properly from the beginning, and then by the time they get to an attorney and you're asking these questions and these things are not in place, it is again, it's heavier. The lift is heavier on this side than it would have been on the front side. So again, I know artists and just talent in general, they're focused on the creative aspect and they're focused on creating music, but remember, you're the business. So as much as it would be fun to just do the fun things, you got to get down to business too, because at the end of the day, it is a business. If you want to generate an income and live off of this, you got to move in that same manner. If you don't have this set up properly, you're not going to be able to collect your royalties. You're not going to be able to collect the money that is owed to you. Your hard-earned money is poof. It's not going to be in your bank account. I'll tell you that much. So yeah.
I would also say it's like it's a difference between I'll give you two examples. So one is a client who have obtained a certain level of success at the time that they've come to me. They probably were making 6 digits yearly by the time they have, kind of come through my offices. And then we had a whole, the client had a pretty extensive catalog, and we've spent a couple months, I would say, probably registering it, throughout all of the different platforms, getting all the collab agreements, licensing agreements in place, making sure the separation of the royalties is proper identified. Now the client, after, and that was like 3 years ago, I would say, right when the client was starting out. Well, now the client is making $1.5 million a year, I think, from all of those sources of revenue that have been, collecting funds from him, and has a substantial offer for purchase of a catalog in front of him, just as a result of that being properly registered from the get-go. And after we've performed the original registration and helped him out, it's not like we were needed for every single song that needed to be done here. And that's also an element of, I think, a proper like client and lawyer relationship, is that the lawyers should not only perform the function, but also to a certain extent show the client how to perform the function if the lawyer is not needed to perform the function. It's, if you know how to register, perform those registrations, I don't think that there's anything bad about you showing the client how to do it, right? So they can do it themselves, because oftentimes there is that hesitation, like, oh, I don't want to reach out to my lawyer, oh, they're going to charge me, or they're going to, give me a 13-page breakdown via email, and I'm going to get confused by it, and I don't want to do anything about it. So instead of that, teach the client to make sure that they know how to perform those registrations. So they, so 3 years later, you look at them as like, oh yeah, now you're making 7 digits. Look at you. That's much better feeling than when you have somebody come to you and say, well, 20 years ago, I've had somebody, steal my music, or this label release something and they never registered it. Can I get it back? It's like, okay, there's some things about statute of limitations and how far long into the past you can claw back some damages. So there are some limitations on that, and you can't always rectify everything that has occurred in the past if you're way too far into the future.
No, yeah, this is what he said is so key. When you closed mouths don't get fed. If you do not ask the question, the answer will be no. So if you don't know how to do something, and you have people around you that do know how to do that, and it might not even be your attorney. Sometimes the manager does this role. Again, depends whether you have the manager in place, but just getting in the mode of doing this consistently, as you can see, went from 6 figures to 7 figures. And then I'll tell you this, no one's going to want to acquire catalog or acquire any IP if you don't own the rights to that IP. Imagine there's this amazing opportunity, but then they start doing their diligence and they don't see everything that's supposed to be there. And now you kind of blew it because you didn't do your part. And now, that's potentially a deal out the door. So it's cumbersome and it's time consuming, but it's definitely worthwhile, and it will pay off in dividends in the end, as you can see with Alex's client.
Yeah, I'd say any business, whether you're a tech startup and you're, putting together your app and you're trying to, make sure that at the end you're looking at the exit strategy, right? Every business should have an exit strategy. What is this, something that you want to continue doing forever until you hit the ground, or is it one of those, oh wait, maybe 20 years down the road, I want to, stop releasing 3 albums a year and go enjoy my cocktail at a beach? Yeah, so it's like one of the, if you're not thinking about the exit strategy, which would require somebody purchasing your work, right, or somebody executing a certain format of a deal with you where there would be some assignment of rights, whether it be an equity firm, whether it be a music inclined company that wants to give you, that wants to purchase your stuff, but then also manage it or give you a percentage of revenue. But regardless of that, there will need to be a point at which you are the owner of the IP, and now you're selling that IP to get a lot of money and not have to work anymore. And for different people, those are different numbers, right? But you can see, if you go into the news, you will see that a lot of musicians are indeed selling their catalogs, and it's just there is a certain proper business sense to it, in that if you've been making yourself up to this point, it's a good idea in some instances, if the money is worth it, to cash out, but you won't be able to do that if you don't have your ducks in a row. If you don't have, if you need to chase somebody down and agree with them for the difference between 12.5 and the 13% that they're getting in the song, and now you're in the midst of it, while you have a $10 million payment on the back end sitting and waiting for you, well, A, you're gonna be in a bad leverage spot, but B, you're just gonna waste a lot of time and maybe get the deal, off the table, unfortunately. So yes, do things properly the first time to avoid having to fix them.
Let's get into protecting your brand, your image, your stage name, best steps for new artists while we're talking about all of these other avenues of um, income, monetizing. How do we protect the brand?
So again, I'm going to bring it back to my favorite line. I'm a businessman, not a businessman. So think of you as the business, but then there's also all these ancillary businesses, right? Artists, actors, any type of talent, they don't just make money off of their primary source. And 9 times out of 10 is actually not their primary source of income, but what they're primarily known for. They make money doing multiple different things, building different brands, building Beyonce just dropped a hair care line. Artists make money with, they have liquor companies that sponsor. There's so many different ways to make money. And the biggest key here is to protect whatever brand it is that you create, that you build, your personal brand, but then also any brand outside of that should be protected. We kind of went through copyrights. One of the ways that you can protect your IP, protect your stage name, and protect your brand is through trademark law. Most people are familiar with what a trademark is, but I'm going to break it down. A trademark could be a symbol, it could be a word, it could be a logo. It's used to identify goods or services. Once you see, I have this bottle of water, Fiji. When you see this, you know right away that I'm not talking about the location, I'm talking about the water. This is used to identify this particular good. Same thing with trademarks. A lot of artists have stage names, for instance. So Alicia Keys, that's not her legal name, but she has that protected. Taylor Swift is queen of trademarks. She has hundreds of trademarks. She has her initials trademarked. She has her name trademarked. She has her signature trademarked. There's so many different facets. I'm going to break down some of the different types of trademarks. We covered wordmark, right? A word mark protects simply the words. So let's say you are, okay, Cellulose. I think, what is the rapper's name that just won? What is his name? You guys remember the lawsuit? Flow Rider, I think, right? Yeah, I think he had like an endorsement deal and was one of the founders. In any event, say that you want to protect a word. Sometimes words also have stylized logos. Like let's say Nike, for instance. The word Nike appears in capital letters, italicized. But we also want to protect the actual word if it's not used within that certain style within that logo. So that would be considered a word mark, whether as a design mark would be the actual logo. It could also be the swoosh. It could be the slogan, just do it. Word mark, design mark. Now you can also have those marks put together, a combination mark. It's the actual word and the logo together. Slogans, as we mentioned, can be trademarked. So one of the most popular slogans is "Just do it," or "Kit Kats have a break, have a Kit Kat." Sound marks. Sound marks are also super important. One of the most popular sound marks is the Sony PlayStation, the sound that comes up when you start playing. Netflix has that distinctive sound when you turn on Netflix. The Paramount, the big lion, when that movie starts. All of these sounds, when you hear them, you'll associate them with a particular service or good. Color marks are also important. So say you want to do a collaboration with Tiffany's, and an artist, wants to. I think there was actually a sneaker line. I can't remember what artist was it. Travis Scott that did something with the Tiffany's blue.
Probably
someone. That Tiffany's turquoise/blue color, you see that color and you automatically think Tiffany's. Or for instance, if you see a red bottom, what are you thinking? Your mind's going straight to Louis Vuitton. The colors play a significant role as well. Certification marks. So I'm going to go take it back to Beyonce because she's one of my favorites. Beyonce, I think, did like this vegan challenge and was 21 days vegan. They're actually like certification marks that help identify whether, like, okay, I think there's a USDA organic seal. So for any food items that are organic, they are able to have this trademark now to identify them as such. So maybe if Beyonce is partnering up with this company, they need to have that seal to legitimize themselves. So this is kind of thinking outside of the box of how this trademark can be used to accelerate and generate additional revenue. Of course, you know, for Beyonce, who is now has a whole audience of folks who are looking at her and who are influenced by her. Now they see that she's associated with this company. This company needs to legitimize themselves, and they're able to do that by a certification mark. There's trade dress. Trade dresses can cover the packaging. So say, again, I'll take it back to Tiffany's, the way that something is packaged and the way that it is, if it has a distinctive packaging and you recognize right away that this is associated with this product. I'm giving you guys an overview, but the way that artists use their trademarks, again, like I mentioned, Taylor Swift doesn't only trademark her name, her stage name. She trademarks her the names of her albums. She trademarks some of the lyrics from her songs that gained a lot of popularity. She's trademarked that. She's trademarked the name of her fan club. She's trademarked her concert, the names of her tours. She has trademarked all of the things, let's say. And she is able to use that and now enter into different types of endorsement deals and sponsor deals. So the way that the USPTO works, the USPTO is the United States Patent and Trademark Office, is they're not giving you a blanket permission to use your trademark in connection to anything. So when we think of Apple, we're thinking of electronic items, right? But Apple doesn't necessarily have a trademark in connection with, I don't know, selling furniture. Their trademark is solely in connection to how they're actually using it in a commercial context. So it's important for artists and talent, just generally speaking, to ensure that their marks are associated with the ways that, one, they intend to use it, or two, that they currently are using it. So with Taylor Swift, again, she has her trademarks in connection to clothes, entertainment services. She has stationery, t-shirts, notebooks, jewelry, linens. Like, she has the linen line now, keychains, lanyards, hair accessories, perfumes. Again, Beyonce with the hairline. They need to identify and be strategic on what potential deals they could have and making sure that their name has that protection with whatever industry that they're looking to get into. I think of, for instance, any of the like Michael Jordan with the collaborations with Nike. Jordan is a very popular trademark. Nobody can go sell a sneaker and call it Jordan's because they have the exclusive rights to that. When you have your trademark in place, it essentially, the value goes up. You are the only person that can use this in connection with selling this product or this service. I'm going off, and I wish there was an opportunity for you guys to ask questions. If you do have questions, definitely drop them in the chat. But the idea here is that once you get the proper protection, then you literally, the price goes up. If you want to sell, as an artist, I want to have a jewelry line. Now I can go to whoever I want and say, I have my trademark and it's in connection to jewelry, and I want to do this deal with you guys. I want to do this collaboration with you guys. If you go to this jewelry maker and you don't have that, they may not feel as though their investment is as protected. They want to make sure that nobody else can go and start selling this trademark, this jewelry line with, you know, your trademark or whatever it may be. They want to have those exclusive rights. Think of exclusivity. The more the exclusivity comes with a price tag. If you're giving someone the rights to use something, you get to charge them more, because essentially you could decide that you want to work with 3 different jewelry companies, and you could do that if you don't give them the exclusive rights, because you can take your trademark and have a non-exclusive license versus an exclusive license to use it. One of the most popular, most recent cases of trademark law that I love to talk about, I don't know if you guys remember, like, the Barbie movie. They did so many collaborations. I don't know if you guys, they hundreds and hundreds and literally so many collaborations. Everybody had a collaboration with the Barbie movie. Fast food restaurants, luggage company, I mean, everybody had a collaboration. And a lot of folks thought that, you know, the marketing budget was what pushed that, but that was all the power of a trademark. All of those deals, there were trademark deals that allowed for that to happen. Not only is Barbie taking their trademark and utilizing it as a means to advertise for their movie, but they're making money off of those things. They, whatever the negotiations are, whatever the deal is, say, for every article of clothing you sell, I want X amount of percent. not only are they making money off of it, but they're advertising for their movie. So this is the power of trademarks and how important it is to put those in place so that you can leverage that and so that you can get the best out of your deals. Alex, am I missing anything?
I would say generally, right, like when you're looking at the strategy, not everybody, has the Beyonce budget, right? And when you're looking at like, oh, where do I dedicate my funds at the beginning of my career or in the middle, whatever you are. But you want to protect at the very least the main assets of your, like what it is that you do. If you're a musician, that usually is going to be class 9 and class 41 for specific, MP3s, right? The actual music work product that you're releasing, and then your entertainment activities and your entertainment services. As a music artist, those would be the primary 2, 9 and 41. Then depending on how you see your business ventures kind of expanding. Oh, I want to get a clothing line going. That's apparel. That's class 26, right? Oh, I want to get jewelry going. Oh, I want to make sure that I'm creating hats and backpacks and bracelets and whatever the case may be. It's a similar kind of thought process to where you are putting a claim or taking a claim to a certain category by filing those intent to use applications. Your trademark applications can be, I'm already using it in commerce and here's the proof of me doing so. Or it can be, I haven't started yet and I'm going to have another 3 years, six months increments to prove to people that I've started using it, but I'm kind of putting a claim into it. And then, if I do start using it in 2 years and I could provide you with a proof, now I'm going to have full registration. But until that happens, or until the mark or the registration is abandoned, nobody can take on that name. So you're kind of getting that exclusivity onto it. So I always think that there are certain trademarks that are must-haves for businesses and the musicians alike. But then there are some that are just dependent on the budget and your existing roadmap. And this is exactly the moment where if you go to a lawyer and you kind of go at it like, oh, can you register all the trademarks for me that I might ever need, right? Like that's not a very intelligent inquiry. It needs to be a little bit more about here's what I'm planning on doing and this is my budget and let's protect the things that make the most sense in accordance with the priorities. And this is where it's very important for a client and the lawyer to work together because both of them have portions of the equation with the knowledge of the business and the knowledge of the law that don't work without one another or just not efficient without one another. So yes, have those conversations with your lawyers. And if you are planning on releasing a specific line of products, get a trademark towards it before you do it to protect yourself and get some additional protection before you even get the products going. But then at a certain level, when you do have the budget and in some instances you're going to have ideas, not necessarily even executions and not necessarily even money flowing from the specific execution, because usually at the earlier stages I recommend if your budget is tight, wait for something to start bringing you money and then register a trademark to it, just because otherwise you are just going to be investing into trademarks for things that haven't started bringing you money. But if you have the budget, then get as many as possible to protect yourself as best as possible. It's just going to be a game of, if you're Beyonce and you can have 300 trademark registrations done in a month, and then 10 of them bring you money, you're probably winning at the end of the day either way. But it's not everybody going to have that opportunity. So you have to be a little bit more, conscious and, thought through in that approach.
Totally agree. Oops, sorry.
Oh, I'm sorry, Rebecca. I didn't mean to. Before we move on, though, Harry has a question in the chat. He's asking, is it current that companies buying their names globally, like in different languages?
Do you
trademarking their names? Is that what you mean, Harry?
I'll touch on. So what we're talking about are trademarks in the U.S. So the United States Patent Trademark Office will. We're speaking about that process because we are licensed to practice law here. However, it is important to consider having trademarks in other countries, especially other countries where your music is very popular and where you feel like you can generate income, because just because you have a trademark here doesn't necessarily mean you have protection everywhere else. There are some bad actors who are, it's called trademark squatting, where they see that there's a trademark that's doing great in one jurisdiction and they try to file that trademark in their country or whatever it may be. So again, it's really strategy, because unless you have an unlimited budget, you can't sit there and get every single trademark for every single line for every product, for every service in every country, unless maybe you're Beyonce in that case, but or Taylor Swift, right? But
or you have an
or that too, right? Okay, someone's the money man.
Yeah.
For most people, that's not the situation. But again, it's strategy. I've had some clients who have been overly ambitious, who wanted to trademark all of the things. And now when it's time to submit the proof, to submit the specimens that you're actually using this trademark, it doesn't happen. And the trademark office gives you a limited amount of time to prove that you're actually using it, because what they don't want to do is have you just sit on something that you're not using. That's not fair. Someone else could potentially use that. So yes, they give you the opportunity to like hold your place, but ultimately you're going to have to prove that. So again, there have been times where there have been clients who've been overly ambitious and have, wanted protection in 5, 6, 7, 8 different classes, and kind of have to reel them in, saying, okay, let's talk about your short-term goals. Let's talk about your long-term goals. Let's talk about what's feasible. And then kind of bring them back in. Again, it really depends on the budget, but ultimately you do want to think of yourself as a business, not just your personal brand, but all the different business ventures that you want to eventually join. Because I will tell you, some of your ancillary businesses will actually be your primary income. So I know for a lot of different artists who are associated with different liquor brands, that's bringing them more money than their music. So that is an important part of their business plan. And that's kind of where the strategy comes in. So I'm going to invest my money into the streams of revenue that I think are most promising.
Yep.
Again, depends on where you're at in your career, but it's certainly something to, I won't say keep in the back of your mind, keep in the forefront. But again, just be strategic on how you approach that.
So Harry added, let's say you have your trademark in the US and another company wants to come along and have the same name, but in another language. Is that possible?
No, you're good. For the most part, you have to provide whenever you are registering your trademark, if there is a certain foreign alternative, right, translation to it, you need to provide it. And then the comparison of likelihood of confusion is going to be between the English versions of that word. So you can't come in and register the word that would mean Nike, right, but in Spanish, right, or whatever. I don't know how that would work, but you know what I mean. When there is not a name, but yeah, whatever the case may be. No, that somebody can't come in and do Apple in Spanish and then say like, well, I'm going to be selling phones now. No, there is a certain level of due diligence that the USPTO does that will prevent that from occurring. I would say, like, in regards to the general kind of like art, you mentioned something about artists being a little bit too ambitious right in the beginning and trying to claim registration towards everything. One of the things that I've seen, clients do sometimes without kind of regarding the trademark process and what can be trademarked is folks taking on and paying a lot of money for domain names that end up being descriptive. That's one of the scenarios where the descriptiveness is another like second element of the analysis by the USPTO. Like first is like, oh, does your mark look like something else that's in a similar line of industry? That's likelihood of confusion. The second one is it descriptive, meaning is the mark conveys what you are selling? Like if you're an Apple brand, you can't be selling apples to people because then everybody else who's selling apples can't be selling apples to them because you've claimed the name, right? So you can't have, and this is where unfortunately there's a discrepancy between the domain name is going to be as valuable the more descriptive it is, but the more descriptive it is, the less likely you are to register it as a trademark. So I've had clients come to me and say, well, I've just spent $5,000 on this awesome domain name that I have to look at and say, well, you can't register a trademark to it because this domain name is literally the description of what your business is. So you can't register it as a trademark. So yeah, in that sense, having some thought process in the beginning and consulting with an attorney, coming back to things, we mentioned LLCs at first, and I think, correct me if I'm wrong, but I generally think LLCs and copyrights are the two things that artists for the most part can do themselves if they have, if they know how to do it, if they've done it once, etc. Trademarks, I've not seen a lot of success stories by clients doing them themselves and then me not having to fix it, because there's just a certain number of like that levels of analysis that go into it.
And then I want to touch on something that you said that I often hear from folks. Having an LLC and having a trademark are two different things. Oh. Just because, say, Beyonce, LLC, that doesn't mean that now I can exclusively use Beyonce, because all that is the name of an entity. That's all that it is. And that's for that specific state. Now, trademarks, it's twofold. You could get a trademark in a state. Most lawyers, I'd probably say 100% of lawyers do not recommend this, because are you only operating in one state? Likely no. You're likely operating all over the US, really all over the world. But getting a trademark through the United States Patent Trademark Office is what's highly recommended, as opposed to getting it on the state level. You're getting it on the federal level as opposed to the state level. But they're two different things. So I don't want you to mix them up thinking that like, oh, I have my trademark, but it's really your LLC. You need both. And typically your LLC would actually own your intellectual property asset and not you as an individual. So again, protecting, keeping things, as we discussed earlier, keeping the business separate. I like when, artists, and it depends on what the situation is, but having an LLC for your intellectual property, sometimes that's important. And again, it depends on the type of deal that it is. Like say you want to start franchising, I don't know, a food company, whatever. What is the one, the Licking? Some of you guys may know the Licking, it's Khaled and a few other artists started it. They actually had to change their name because it was too confusing to, I think initially it was called Finger Licking, but it was too confusing to something. I think Popeyes or one of the companies that KFC, there you go. So that's like a perfect example of an artist having a venture and I'm not wherever there was a lag, but at some point there wasn't the full due diligence that was done. So now they had to rebrand and now they have to call it the Licking. But I'm saying this because, again, you don't want to find yourself in a position where you have to now rebrand because your name is confusingly similar with another brand. And sometimes it's the exact name. I've had a client who's come to me who's operating for 6-7 years, super successful, has worked with your favorite artist, and the name of her company, her production company, is registered by somebody else. And I tell people it's not a question of if you're going to get a cease and desist letter, it's a question of when you're going to get that. Especially if you have traction, especially if you're working with Drake, especially if you're working with all these different artists, it's only a matter of time until someone comes, sees that, and you're going to get a cease and desist letter. And the monetary damages can be pretty high. Whatever you're making off that trademark could that could be on the line of what you have to pay.
Yeah, I'll give you one of the kind of examples to that is it's not necessarily in the music space. It's it's a physical entity, brick and mortar. But I have a client right now that I'm defending a trademark litigation, and the client has been around in Florida. His establishment has been since 1996, unless I'm mistaken, or it's registered as an entity since 1996, and probably has been around since like the early 90s. And there was a competing entity by the same name that does the same thing, but in the state of Rhode Island, that has been around for 35 years, since like the middle 80s. And the Rhode Island entity is the one that has the trademark. Our client doesn't. So they have coexisted for 20 years doing exactly the same thing without anybody ever blinking an eye. And then, at a certain point, we've received the service of process and, the complaint and everything. So it's one of those things where preventative measures help you avoid costs in the future. And yeah, getting proper registration just eases so much pain moving forward if you do it right. It just you do it once, and then you're gonna have some renewals to do every 5 years, and after that you're just as you're continuing to use that mark and getting revenue from it, it's better to have it than not, for either the offensive or defensive purposes, because in some instances you're going to have some claim saying like, oh, I want to start this business, but you're already using this name. And this is where having the trademark registration, specifically with domain disputes, right? If somebody's trying to do something similar to you and they want to use that domain, but you've already got the the .com that everybody wanted, having the registration is going to be of much assistance to you defending those claims, in addition to you going in an offensive and preventing other people from using your IP. So
I like
highly recommend, 5 stars.
Come with your receipts. When you have that registration, it's easy. I mean, it's not going to be like a slam dunk, but it's going to be significantly easier than having to fight and prove. I mean, especially, as he's saying, these companies have been around for 30 plus years, which is insane to me. But again, it happens, and it's better late than never, right? Sometimes folks think that like, oh, it's too late, I've been doing this. No, it's better late than never, because the longer you use a trademark that may not be available to you, the more you're pouring money into a brand and a business that you don't own. I know I say this all the time. I have so many colleagues in the space that say this. The question is, would you build a house on land that you do not own? Most people are going to say no. They would not build a house on land they do not own. But a lot of people are building businesses and brands that they don't own the IP rights to. And you're pouring your blood, sweat, and tears. You're working so hard. And now you really want to be able to enjoy the fruits of your labor, but you can't because someone else has that trademark. And now you have to rebrand, and not necessarily start from scratch, but it definitely does, hinder business. And you don't want to put yourself in that position where you can't build right the type of revenue you want to because you did not do your due diligence on the front end and ensure that trademark is available to you.
Yeah, but might make you look a little bit foolish as well when you have to change your whole stage name in the middle of your career and explain it to the existing fan base why that is so. It's like, oh yeah, I haven't checked my trademark registry 4 years ago. Like, okay, cool. Now we need to start looking for you at Spotify under a different name. That's that's user attrition. That's where you lose people.
Yeah, and again, it's avoidable. So for what we can avoid, let's try to do that. Alex mentioned something that's also important: maintaining your trademark. It's not a lot of work. Every, I think, 5-6 years, you need to. There's the maintenance part of this, maintenance of the LLC as well, or whatever your business entity is. So if you're in the state of Florida, May 1st is when your annual reports are due. Make sure that you stay. You don't want to have to reenact your entity because now it's been dissolved. There is the part of the foundation, but then there's a part of maintaining it as well. It's a lot to think about, but all important pieces.
There's another question in the chat from Naya. It's about copyrights, and she's asking if you can speak to having the artist execute the agreements, but directing payments to their company. So regarding issues that come up with termination or reversion of those rights later.
Well,
does that make sense?
I'm not necessarily sure about how the termination would affect it, especially if you're working in the context of a loan out company, that means that you have an LLC that you're in full control of. Either way, is just you are executing the agreement on behalf of the company, and then you usually add an inducement letter, at the bottom saying that I, as an individual, agree to this engagement between my company and whoever is the person giving me money. And now you don't have to redirect payments. You just have the payments go to the LLC because it's the party on the contract, and then they are redirected to you as an individual on behalf of you being the owner of the entity, or if you have an agreement with your loan company for a certain distribution, however you go about that. But generally speaking, like as long as you're in control of the contract in that sense, right? You can always, you're going to have the same rights as to whether terminate that engagement and redirect it directly to yourself as an individual or redirect it to the company, regardless of whether you execute agreements on behalf of yourself individually or as a loan out company, because you control both yourself and your company. So there's always that flexibility. I would say just make sure this is where having an accountant on your team is of much use and help, because the majority of, obviously outside of the the legal aspects of having a limited liability company, like protecting yourself from liability, there is an additional element of, oh, is your company taxed as an S corp? Is it taxed as a C corp? Oh, are you deducting expenses? Oh, do you have somebody managing your revenue streams to make sure that your tax liability is lowered? So this is something where having a CPA on your team, right, an accountant, is of much assistance to make sure that just follow whatever is going to be the most efficient approach for you in terms of where you direct your funds. So
thanks, Alex. Let's get into negotiation and knowing your worth, finding the right partners.
Let's do it. Rebecca, you want to start us off? You want to talk about some licensing stuff? You want to go into the sponsorship stuff? Where you want to go?
Sure. We talked a little bit about the sponsorship and endorsement deals.
Yeah.
You definitely want to position yourself in coming to these brands and sometimes they're coming to you. Honestly, the best case scenario is that they're coming to you and you have that leverage. And I always tell myself, stay ready so you don't have to get ready. So say there's an opportunity to do a collaboration, but you don't have your IP in order, then it's going to devalue the deal, right? I always say that exclusivity costs more money. If someone comes and does a deal with you and they want that exclusivity, they need to pay up. Versus if we just want to be able to do this deal with you, and we don't really, not necessarily that they don't care who else does this type of deal with you, but most of the time you're going to see these brands, they want that exclusive, right? Because they want all your fans to come to their, like, let's just say a sneaker deal. They want all your fans to purchase that specific sneaker, and 9 times out of 10, they're not going to want Adidas or Reebok or whoever else as a competitor in the space. It sometimes dilutes the value of the deal if your fan base can go anywhere to now purchase items with, you know, your stamp of approval. That's more of an endorsement deal. There, you know, even with content, creating content, you can make money that way. And again, you can work with a brand to create content. And if you give them that exclusivity, and if your IP is protected, the value of that deal goes up. With anything, right? You have to make sure that you do your due diligence on your end. Alex was mentioning, like, you don't want to come and say, like, you know, I have to now rebrand because I am infringing on someone else's IP, and now that kills the deal. Another case scenario that occurred to a client was they were doing collaborations with several Fortune 100 companies. So collaborations, let's just say like Fiji, and I have C4 here. So I'm going to use what I have. Say Fiji wants to do a collaboration with C4, the collaboration thing. Now, if Fiji is infringing on someone's mark and they're using it in combination with C4, C4 can potentially be put on the line for Fiji's infringement because they're using it together. So we definitely don't want to do that. You wouldn't want to work with a brand and they're utilizing IP that you typically, in these contracts, you make a representation that you own the IP, and then say you don't really own the IP. And now there's a lawsuit. Most of the time people are going after the person with the deep pockets, the people who have the money that could pay up. You don't want to find yourself in that position because it will absolutely kill a deal. And 9 times out of 10, there's something called an indemnification provision in your agreement, says that if you don't actually own this IP, and if we do get sued, you're on the hook. So doing your diligence from the front end, again, it's the same thing that we've been stressing this whole, you know, this entire morning, is super important, because on the back end, you don't want, one, to kill the deal, but then two, to then now be responsible for all of the monetary damages plus legal fees associated with the infringement.
Yeah, when it comes to negotiating also, right, it's depending, regardless of what side you're on, honestly, because, you know, we, in our practice, we have both brands who are looking to get connected to artists for certain, you know, marketing engagements and executions, like, oh, create a video for us, right, and then post it on social media and have it be up for X amount of days, and then do a story, tag us, do this, right? So I think the main thing, and, you know, the very important thing, is for both sides to have a clear understanding of what are the things that I'm supposed to do, or what am I expecting the other side to do here. And then depending on that breakdown, there is a conversation about a compensation for each one of those, right? If you're an influencer, if you're an artist, and you have a brand coming to you and saying, oh, I want you to participate in the music video shoot, and I want you to, you know, do this post promoting our brand, and then I want you to do this native story just showing how you're using the brand. Each single one of those is going to have duties associated with it, and hence it's going to have compensation associated with it, and it's going to have rights being granted or transferred, right? If you're a brand coming to music artists to do any of those 3 executions that I mentioned, the brand needs to license their trademark to the artist in order to be able for the artist to create content using the mark. Now, the artist, on the other hand, needs to assign that IP or have that IP be a work for hire for the brand, so the brand then can use that content creating using their trademark for their future promotional purposes. And at each single time where you look at, oh, this, I need to transfer rights here, or I need to get some rights from somebody, there needs to be an understanding like, well, I need to be paid for that, right? Or I need to pay somebody for it, whatever side of the equation you're on. And that is the way to kind of structure the deals fairly, right? And there is some additional elements in the, you know, in the weeds between the lines that are going to come into play, like, oh, some might money gets paid up front, and then you reserve some money to kind of later stage to make sure that you have leverage over an influencer who has 15 different things going on at the same time, and you want to make sure that their post comes out on Tuesday at 9:30 a.m. on the dot, right? That is where you go into that negotiation, but generally speaking, make sure that you know what you are executing, and where your business management team knows what you're executing, to make sure that you can deliver, to make sure that you can get paid in full for it and not get taken advantage of.
Yeah, just to piggyback off of what Alex said, really key. I had a client who was invited to co-host for a show, and that turned into her hosting the entire season. It turned into her producing for the show, and it turned into her promoting the show. So we started off with one episode, ended up having 12 episodes, promoting and producing. These are all different checks. These are all different line items, because my ability to produce has nothing to do with my ability to promote, and it has nothing to do with my ability to host. You really want to remember and think out, think comprehensively that, brands are always going to try to throw a lot of things into the deal, but the more you itemize and the more you're able to show, this is separate service than this. And it's up to you, because remember, you're the business, because there are times where, some deals, they consider the promotion and the hosting one and the same. Maybe as part of your hosting duties, they require you to post 3 or 4 times, whatever it may be. You can enter into a deal that way. But if you're able to show and leverage that your promotion, like the value of your promotion is worth X amount, that's another stream of income that you're making off of the promotional activities that you are providing now, those promotional services that you're providing to that certain business. It's easy to, like I said, it's easy for a business to try to throw in a bunch of things, but you also don't want to put yourself in a position where you're not able to deliver, and now you're in breach, and now maybe you're not going to get your full paycheck or none of it. You want to make sure that, and it's also just for reputational harm. You don't want to have, be the person in the industry that's known as someone that's so hard to do deals with, because there are people who have this type of reputation, and people don't want to work with them because, we are nervous they're not going to deliver. And this is a very important launch for us. So we need to make sure that this person's on point, and they may not want to take that risk with you because you've developed this reputation where you just don't follow through. And not all the time is someone going to hold you liable for that, but it could hurt in the sense that you won't get future business from other potential companies and brands, because now you've developed this reputation of, I'm not dependable and I can't execute when I say I can.
Yeah, and I think you need to, and that's where that element of like you taking responsibility for your career and you're being involved in decision making happening throughout your career. One of the unfortunate things that I see is that some artists who have gotten to a certain level, right? Obviously, they've gotten to it, because of their creative capabilities, because of how talented they are, how diverse they are, how good of a performer they are. But at the end of the day, if there is a certain aversion to anything and everything business or law related, which unfortunately is the thing that I see a lot when it's like, well, you guys deal with this. Like I'm just gonna be in the booth doing my thing, right? What happens there is that you are lowering your chances at having a thought through career when you are understanding of what's happening around you, pretty much, because you might have somebody come to you and the only thing you care about is like, oh, they're offering me $50,000 for this. Okay, cool. But you don't get into the weeds of, okay, and now I'm, for the next 4 months, I need to be posting weekly about X, Y, and Z for this and this, or I need to be participating in these promos and these events, these performances, whatever the case may be. Just as a matter of be in control of what you are agreeing, and don't be afraid to ask questions. And it also can be a very eye-opening experience when you start asking people questions and they start getting frustrated with you and saying like, well, no, just sign this. Why you have to be so difficult about this? Anytime you have somebody pushing you into an agreement or trying to have you sign it without having an attorney take a look at it, or do it right this very second because it needs to be done by Friday's end, or the deal is off the table, that deal yeah, it's like, what else is new? Like, yeah, sure, but I'm gonna do my due diligence and I'm gonna make sure that I know what I'm signing, instead of just signing it and then trying to figure out how do I get out of this deal that doesn't have a termination clause.
And then you also want to make sure you're not breaching another agreement by entering into that agreement, because maybe somewhat you've already signed and they have exclusivity or whatever. for live performances or personal appearances, sometimes there's provisions in those agreements that say you cannot perform in a 50-mile radius for the next 45 days, whatever it may be. Now you rushed and entered into another agreement because you saw a check, but then didn't realize now you're breaching this 6-figure check instead of this 5-figure check. And again, it's a mess that you don't want to really find yourself in. Another thing that we haven't touched on is revenue sharing. There are certain deals where you can actually have a revenue, like an ad rev share split, depending on what it is. So say it's a show, or say it's, ticket sales, you may be able to negotiate a certain percentage. And sometimes it's in threshold. So if we sell 10,000 tickets, you get X percentage of this, and then 20,000 tickets, X percentage of that. Again, 9 times out of 10, it's meant to incentivize you to promote the show, because the more people that they sell tickets to, the more money that you could potentially get. And that's the same thing that goes for merchandise. If it's 9 times out of 10, it works both ways. The deals can be structured. There's so many ways to skin a cat. You can get a lump sum. You can get an additional compensation based off of the performance. There's more than one way to get compensated than, your traditional, we're going to give you a $10 million deal for this collaboration and that's it. I think it's good business when there are built-in incentives for the campaign. If it does well, whatever it may be, I think that's always good on both sides. The better this product does, the better this launch does, the more money everybody makes. So that's another way that you can increase your bottom line when doing, when entering into sponsorship deals, endorsements, shows, any of that.
Yeah, it's the same kind of the logic when it comes to, imagine you are a toy brand, right? Or you're an animation brand, right? I have some experience with those. It's pretty close example to myself. You have some visual property, and then the majority of funds in the animation business or licensing business comes from licensing, is because you have agents distributing your IP to different producers of specific goods like toys and clothes and all those things that the IP kind of grows from in terms of its monetization. It's the same thing with your music careers, that you want to control as much as possible, and this is where that first steps of clearing and getting all the agreements with everybody comes in, right? And registering your copyrights and the trademarks. Now that you have the whole scope of your IP on the copyrights and trademark side and both types of copyrights and all of that, and you have the contracts to support you, now you can think about monetizing it by licensing it to people, right? And this is like, if in the first kind of stage of that process you are trying to get as much as possible, in the second stage you are trying to retain as much as possible, because if you give somebody an exclusive deal to the territory of the United States for anything and everything related to apparel, well, now you can't then enter into another apparel, deal. But if you limit this particular transaction to, let's say, exclusivity, but only towards jeans products, because that's what this company does, and it doesn't need the exclusivity for hats, then you can go to the hats company and get a separate license with them, also exclusive, but limited to the hats exclusivity, right? So just make sure to retain things so you can sell it to other people.
That is where specificity comes in handy, right? The broader you are, the more limitations that you'll have. If you just say apparel, you just close yourself out of all these different opportunities that may not even have an effect on, like, if I'm doing a deal with Levi's jeans, right? Another way to generate additional income from performances, I'm actually dealing with this issue now. I represent a music festival, and we are in the process of negotiating all of the talent, the live performance agreements with talent. There is an individual who wants to bring on their liquor brand as they as part of the agreement. Mind you, this individual is getting 6 figures for a 90-minute performance. They want to require us to buy, I think they proposed around 100 cases of their liquor, and if you do 100 times 12, that's a lot of liquor. And trying to slide that in the agreement is obviously, thank God there's a lawyer involved, because if it was just the music festival organizers and they signed that, and now there's this obligation to buy this liquor when we actually already have an official sponsor and can't have that competition, it's going to be problematic. But I'm not mad at the artist team for trying to use their brand and bring them into the show to promote their brand. So again, depending on what side I'm in this instance, I'm representing the music festival. So I'm going to look out for the best interest of the music festival. But maybe, the artist can try a different pitch. Maybe I want to be able to sell my merchandise at this festival. I have a food truck business or whatever it may be. I want to be able to sell that. And you can try to tie in all your brands into that so that you're not only getting compensated to perform or to appear, but you're also making money off of your brands as well.
And getting additional exposure while you're at it as well, right? Maybe not everybody knew that you were, an ambassador for this brand. Maybe not everybody knew that you were releasing this new, product or new service, whatever. Yeah, just make people, know about it. Why not?
Yeah, the whole 100 case didn't go over well, but you can't be mad at them, right? Closed mouths don't get.
Well, you can always go back to the, well, we have an exclusive sponsor for this thing, so that's going to be in violation of the agreement. So sorry.
Yeah. Yeah.
So before we get into kind of opening it up for any questions from the participants, how do changes in the music industry landscape, such as streaming services, social media, affect the artist negotiation and structure of these agreements?
I would say, Rebecca, would you like to go?
Yeah. Go for it.
I would say that one of the things that we've been seeing, right, and mind you, I have a boutique law firm, right, and we've been, working with a lot of independent artists. So oftentimes we find ourselves at the negotiating table, alongside the artist, trying to negotiate an agreement with the label, with the distributor, right, with the publisher, and so over the years, you see a certain you see some pros and you see some cons, so to say. There's some positive changes, there's some negative changes. I would say on the positive side, it would definitely be the fact that people are straying away, or record labels are straying away from the 360 format, from the I'm going to own all your masters forever, or everything that you've done before and everything that you're going to do in the next 6 years, because California law limits me to not being able to do contracts for more than 7 years. So that's going to be the max that I'm going to put into anything. And then I'm going to have an additional reserves clause that's going to take 35% of your masters for the broken CDs. And then I'm going to have, all the accounting clauses that, make it difficult for you to figure out what it is exactly that you're making, and everything is recoupable. So that used to be, the name of the game until a lot of, major artists, including Taylor, Kanye, and whoever else started, speaking out against it, right? And making sure that, people have become a little bit more educated. So now it's much more difficult for a label to throw, a very, very restrictive deal in front of an artist. Now, those most of those deals now become distribution deals. They become partnership deals. They become, oh, let us license your work for the next 3-5 years. And it's going to be a risk on our end to the same extent it's going to be a risk on your end, because we're going to give you some money, but then we're going to take a percentage from you, and it's going to be up to us to market you to an extent for us to get our money back, which is, a proper way, a fair way to structure those things, especially if the artist has already, achieved some success. But now we go to the second part of the equation where, it used to be that an A&R could kind of put a faith into an artist, like, oh, I've heard this girl perform and her voice is amazing, and I think she's going to be great for this type of genre, this type of song. We'll add her to these projects. Now it doesn't necessarily work like that, because you have the numbers, you have the data, right? So this has been something that I've touched upon in the beginning. Labels used to have to do the marketing for the artist. Now they do the marketing for the artists who've already done the marketing for themselves, right? If you are making X amount of money, if you have 100 or let's say 200 people, 1,000 people on Spotify listening to you monthly, well, now the labels are interested, or distributors are interested. So it has become a lot of the DIY game, do-it-yourself game, where you need to achieve things and numbers and followings and fans before you start getting those proposals. But that is also not necessarily bad, I don't think, to some extent, because it used to be oftentimes that you would be a complete, you would just be a clean slate. I'm just starting out. And that's exactly the position that you don't want to be in when you're negotiating with a Sony, right? Because then they're going to just take full advantage of you. But now, if you have already made some progress, if you've made some money, you're independently successful, you have enough money to have an attorney look at everything, right? Now you can leverage that and negotiate. Now you don't need the deal, right? You can have the deal, you can take the deal, but it's the best position to be in where you don't need the deal.
It's a pick and choose. So I most recently worked for Amazon Music at a digital service provider. And one of the things that I like about just social media, the impact of social media, and just, with innovation and tech, artists have the ability to directly connect with their fan base more so now than they ever have been before. Before, things had to go through the label, through their fan club. Now artists, there's so many artists who blow up on TikTok. They are in more control of their career, at least with respect to, the marketing and promotion. They get to directly speak to their consumer base, essentially. A lot of these different platforms, Spotify, Amazon Music, Apple, they also have artist specific platforms so that the artist can see, okay, where is my music being played? All right, I have 500,000 streams in Austin, Texas, so maybe I need to make sure I have a show in Austin, Texas, or whatever. Maybe there's a lot of data that can be utilized to help an artist make decisions, be strategic, generate more revenue. Amazon had and they still have it, there's an ability to purchase artist merchandise through the app. And obviously everyone knows Amazon is, they're great at, getting something to your house in 3 hours. So now with this collaboration with artist merchandise, you can listen to their music and you can buy their merch. We had an exclusive drop with Beyonce and all of her stuff sold out in a heartbeat. Not all digital service providers are able to provide that, but each provider has its own, twist, its own unique offerings, and it does give the artists more leverage, more information, more data to, really just be strategic in their business approach as it comes to their career.
And I think that also distinguishes the artists who make it against, versus those that don't. Is because, if you are at the beginning of your stage already have that entrepreneurial mindset about like, oh, let me go into the depth of my Facebook analytics and figure out how everything flows in terms of the breakdowns and engagements and percentages and responses and the data. Let me go and find digital service providers that are so many of those, and do my analysis and sit for a couple of weeks and look through different websites and different options and find the perfect collaboration for me, a perfect service for me to create my merch and put a convenient link on the website, right? I can put a convenient link on the YouTube channel. Now, if you are doing all of those things, you're automatically going to be more you're going to be more knowledgeable when you go into a conversation and a label goes like, oh, give us $1,000 for this single and we're going to put it up and it's going to have our label on top of it, and that's what we call distribution. Well, if you know a thing or two about the industry and you know how to market yourself, you're going to know that this is not a good deal, and this is just something that the label at this point needs to come with value that is beyond what the artist can independently do. And there is value still to this day, definitely, in having somebody who knows people, who knows people on radio, who knows what playlist to place you at, etc. All of that is very valuable, but it needs to be properly defined and enumerated, and it has become more of an equal. It becomes more of an equal game if that musician has put in the work to make sure to know how to get themselves further. Because now it's a conversation of two equals, kind of like, well, I've already making $1 million a year here, right? Like, I know how to do these things. So if you are here to take my masters or anything, you better come with something valuable in order for that to make sense for me. As opposed to when you're just starting out and you're just going and saying like, oh, I just want to find some labels that are going to put some money into me and believe in me and, make me go boom, right? It's like, yeah, but the likelihood of that happening without you actually doing the work yourself is so much lower than with the folks who are like grinding and actually are like believing and betting on themselves and putting in the work to reflect that, as opposed to hoping that somebody else will do it out of the kindness of their own heart. So
yeah, it's all a business decision. When a label comes out of pocket and provides you that advance, a lot of the times people think it's like free money. No, it's look at it as a loan, because technically you're not going to get anything until they recoup on their investment. So yes, you're getting an advance, and yes, they bear the risk of not recouping, but at the end of the day, it's a business. You got to put the work in, you got to show the numbers, and they want to see a return on their investment. So I always say, to the extent that you can generate your own buzz, generate your own fan base, generate your own income, do it. You have so much more leverage when you're at that negotiation table than as someone who is just, starting out and they kind of have to take whatever deal is thrown at them.
Yeah, and unfortunately, I think that's the reality of. At least it used to be like that. I think these days it's a little bit more. I think people are more educated, and I think people are more knowledgeable about what is a good deal, what is a bad deal, right? People know that 360 is bad for them, and everybody needs to maintain as much control of their, corporate ownership as possible, and the license is better than an assignment and things like that. And if you can avoid including the back catalog into the deal, avoid including back catalog into the deal. But yes, at the end of the day, it becomes like the more leverage you have, the more you can assert, and you are gonna face some bad actors in the process. But this is where having a team that is experienced in, those agreements and those negotiation strategies is just helpful to make sure that you are not making a mistake of just going in there without knowing what you can obtain from them. Because I've seen record label contracts. I've had a very fun experience this year where a label has put 3 agreements in front of like 3 separate clients of mine, and they didn't know that I represented the second 2, and they had a different admin fee for each one of those. So in the one they had like, oh, we're okay with 5% admin fee on top. The second one was 10%, and the third one was 12.5%. And that admin fee didn't have any elaboration or explanation to it at all. It's like, well, we're going to do this service. There's going to be a, let's say 60-40 split here, but we also charging you 10% on top because we are the admins, whatever that means. There's no additional function for that. It's just like, well, we just want to take it. And it's different to every artist. So I was looking like, I'm like, okay, this is a Wild West happening here. What are we doing? Let's just get rid of that. So, it is helpful to have somebody who's been in those conversations kind of guide you and say, well, this is bullshit.
Yeah. Industry norms is, there's no one way, no one right way, but there's definitely, we can call BS on certain things. And, sometimes people think that, oh, this is a fee that has to be there. It's an administrative fee. Everything's negotiable. Everything is negotiable.
Thank you both. We have about 5 minutes left. Any closing points we want to leave with our participants today?
I'm going to reiterate. We talked a lot today. I'm going to reiterate, closed mouths don't get fed. That is just my advice in life. Every shot not taken is a shot missed. If you don't try, if you don't bet on yourself, if you don't ask the question, the answer is always going to be no. So bet on yourself, advocate for yourself, and closed mouths don't get fed. That's my 2 cents.
Yeah, I would say honestly, take responsibility for your success, right? Stop playing the victim card and being like, oh, the industry is so tough and the labels are out to get you. Yeah, of course they are. They're running their own businesses. They have their own families to feed, right? So if you're not going to get on the same level in terms of you being, handling your business as a business person, right? And making sure that all of the, fundamental things are in place with the LLC creation, having an attorney on the team, having an accountant on the team, and having somebody who is specializing in marketing on a team, right? If it's not you. If you don't have those things, if you're kind of hoping for things to, figure themselves out, that you're just, you're lowering your chances of success, in any industry, and music industry not being an exception to it. What do we got? We got a question regarding generative AI. Well, yeah, Drake is facing a little bit of a conundrum these days because of that, didn't he?
So Philippe is
you want to try?
I'm sorry.
Oh, go for it. No.
It was the question.
I was just go through his question.
Do you mind reading the question again? Is it talking about AI and the impacts of music generally?
So what are your opinions regarding music being the source of generative AI and our ability to enforce intellectual property rights control in the face of it?
So the Copyright Office, their stance is it needs to be created by a human, essentially, for it to be able to be protected. There's so many different schools of thoughts on this. I've worked with a producer, a big time producer, several Grammys. He supports it. He's publicly supported. Timbaland has publicly supported AI and the abilities of what it could do. But then you have some artists who absolutely hate it. I think, if you're, I can't remember the song that he released, but he was able to like bring back to life, like he started a song with an artist. I think it was Biggie, if I'm remembering correctly, never got to finish the song. And now he was able to finish the song. So again, there's, support, there's pros and cons to anything in life. There's pros and cons. I think there's pros and cons to AI. Some artists are okay with their voice being used as AI. Obviously the labels are not here for it whatsoever. They want to be able to control all the money that, is being made, and they don't want any song, going viral, and they're not really seeing any of the proceeds from that. But yeah, I can't say that I'm on one side or the other, but there are definitely very strong opinions about it in the industry.
Yeah, we're
Harry
also
has
seeing.
one. Oh, I'm sorry, Alex. Go ahead.
No worries. It depends on how you use it, right? It's if you are, is it the AI that you use to, exchange, somehow emphasize your own work and add something to it and make a certain, progression of the beat on the background and certain loops or hooks that you want to include in there, and that allows you to do it in a much faster process without having to pay $5,000 to an engineer. Sure, there's value in it, 100%. But if you are using it to create an ad with somebody's voice, with the voice of a celebrity, and create a fake endorsement of it for your brand, yeah, probably not the best thing to do. Everything is a tool, and it just depends on whether you use it for good or whether you use it, and can get sued for it. So just make sure that you're maintaining that same kind of approach to all forms of new technology that come out, whether it's AI or not.
Rebecca, Harry has one last question for you. As an artist that evaluates in a small market, is that a special business model to navigate around and survive before making it to the mainstream?
Can you repeat the beginning part? As an artist that is in a small, repeat it
In
if
a
you don't.
small market, is that a special business model to navigate around and survive before making it to mainstream? So is there a focus on that market being small before they transition into the larger mainstream markets?
I mean, I say find out who your people are and focus on them and build that, right? Typically, your fan base starts at home. You are performing at, smaller shows, and you're just kind of getting the buzz. You're not going to be an overnight, sell out a stadium. I'm a really big believer in doing the work and putting yourself in a position where you do have leverage. And I think the only way that's really possible is if you start, from ground up, grassroots. A lot of the times, that requires you investing into your marketing, going to the shows, introducing yourselves, putting yourselves in a room where you can meet other producers, you can collaborate. A lot of the times people are always worried about getting to the person at the top of the senior vice president of this label that could sign them, but they forget to really look to the person to the right and left of them. I think Issa Rae said to like network across. And I think that's so important because listen, your counterpart here just got signed to this label and knows what to do and how to do it. This is a very valuable person to you, and maybe almost even more valuable than the senior vice president who has never gone through this process. So really finding your tribe, finding your people, surrounding yourself with good people, and then just keep doing the work. My little cousin, he's a producer. He's released a beat every single day for the past 3.5 years. Every single day at 2 p.m., he is dropping a beat on YouTube. And that has paid off in dividends. Hard work, consistent. Don't just drop music when you feel like it. You got to be able to work when you want to and when you don't want to. Alex, would there be anything that you would add to that?
Yeah, I'd say the fact that everybody, from us lawyers to any business, anybody has the extensive range of tools that allow you to promote yourself online, right? You have Instagram where you can go to stories. You have TikTok that is just free marketing that gets you in front of 200,000 eyeballs every day potentially, just because of how the platforms and the algorithm work. So if you're able to handle those, if you're able to master those, then you're not no longer limited to the fact that you are in a small town. But the client that I was previously mentioned, the one that's currently in the 7 digits, literally is in a small town in one of the states abiding Florida. Just, I don't know however many people there are, 50,000 people. And it just was able to blow up using social media and TikTok, and then obviously touring. But it's, if you are not, utilizing the tools in front of you, the small market is not going to be the only kind of limitation that you have. It's all about the drive that you have and your ability to learn new things and utilize them.
Totally agree. Yeah, mindset is important. I wouldn't even say I'm in a small market. I would say I'm a fish in a big pond. That's how I would look at it.
Yeah.
That was great. Well, Rebecca and Alex, thank you both so much for your insight and time today. Thank you all for your questions, participation. Big thanks to Jean-Marie for putting this together for us. He has also dropped the link to the Music Tech Conference as well as a discount code. So if you haven't registered, there's a 15% discount code in the comments. Rebecca, will you add the title of the book that you shared with us?
Yeah.
Harry has also dropped another book. This is All You Need to Know About, is that music industry?
Yep. All you to know about the music business?
Just Donald
right.
Passman. Just Google Donald Passman. He's gonna have like 16 editions of this book.
Donald Passman,
Okay.
Passman. It's like a Bible in the music industry, but there are, I think folks dropped other books as well. There are a lot of good resources.
Yes.
So
Harry also dropped a book in the chat for us. I just put the title of that book in the chat for us. Again, I look forward to seeing you all in Miami in June. And thanks again for joining us today. It's been a great discussion.
thanks,
Thank you
everybody.
so much.
Take
Have
care.
a good day, guys.
See you guys.
Thanks.